Hello, everybody, and welcome to History Bite number 244, dated May 3rd, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled, A Tribute to Chief Justice Warren E. Burger and His Institutional Modernization of the Supreme Court and the Greater Federal Judiciary. This is actually one of my writings from 2018. This is one of many in which I covered various subjects in law and history. And, we focus on the modernization, various types of modernization that Chief Justice Warren Burger put into action during his time as Chief Justice of the United States to the Supreme Court and to the Greater Federal Judiciary. Okay? So, of course, for those who are unaware, Warren E. Burger was the 15th Chief Justice of the United States, serving from June 1969 until his retirement in September of 1986. Warren Burger was born in 1907 and passed away in 1995. For the record, for those who may be interested, his birthday, September 17th, is, of course, Constitution Day in the United States. Okay? Now, among legal historians, Warren Burger, is not greatly remembered for his jurisprudence, per se. The Burger Court certainly is, especially with respect to the advancement of women's rights in numerous areas. However, Chief Justice Burger himself is not greatly known for his jurisprudence. But what he is known for, is being a great reformer, to the processes and aesthetics of the U.S. Supreme Court, the Federal Judiciary, and, as a result of that, the reform of many state court systems as well, okay? Chief Justice Burger was appointed to lead a great counter-revolution, as you probably already know, against the Warren Court's liberal landmark decisions, And instead of leading that great revolution against the Warren Court and its decisions, in fact, some Warren Court decisions were expanded under Burger, it was with reforms to the federal judiciary that Chief Justice Burger ultimately would lead his counter-revolution, as it were. All right? Chief Justice Burger brought the Supreme Court up to code in a litany of different ways, and abandoned many traditional and outdated practices, So, first and foremost, the general functioning and aesthetics of the U.S. Supreme Court today that you see is largely the work of Chief Justice Warren Burger, some 50 years ago now, Additionally, during his years of government service as an attorney and a judge, and of course as Chief Justice, Warren Burger developed a reputation for promoting swiftness and efficiency, in the American justice system as a whole. So he wasn't content with being a, sedentary, quiet, reserved, out-of-touch jurist. Warren Burger was a very activist-minded individual who sought reform, much like a politician, He strongly believed that modernization and case reduction was crucial to a more effective and expedited legal system in the United States, Simply put, Warren Burger was not a man of words. He was a man of deeds. And those deeds are still with us to this very day, long after his time as Chief Justice and his passing, So, having been appointed by President Nixon in 1969, Chief Justice Burger began his great reforms right there at the U.S. Supreme Court, So, beginning in the summer of 1971, while his colleagues were away during the summer recess, the chief took a tour of the building and was not impressed with what he saw. Indeed, he found his own new chambers to be much too small. Berger was very, shall we say, pretentious-minded. So, but he was impressed by the justices' conference room, where they meet to decide the cases, argued the court. And he considered initially making this his ceremonial office, but due to the objections of his other colleagues, that didn't happen. All right. So next, the chief took a tour of the courtroom itself and noticed many things in dire need of attention. First, he saw that upon the bench, all of the chairs for the justices were different. Hard to imagine that today, isn't it? Indeed, in that era, each justice chose their own chair. As a result, the shapes, sizes, and colors of the chairs varied considerably. It was an eyesore, Berger thought it was visually gruesome and made the decision that all 9 members would have the same type of chair, which is why you see the uniformity in the justices' seats to this very day. All right? So, from that, you arguably have the most visible reform to the Supreme Court. All right? Also considered was the straight-lined bench that the justices sat at. Of course, this was the same bench that was in use from the time the court first opened for business in its building in 1935. Now, of course, when sitting in the visitors' gallery, the bench doesn't appear to be angled very much, but indeed it is, okay? The bench is angled so that the justices have greater audio abilities, and so that they can see one another. All right. This was not the case prior to Berger becoming Chief Justice. Okay. And, due to the bench's structure back then, the justices could barely hear or see each other to any reasonable degree. Things got lost in translation between the justices and the advocates with the poor acoustics of the large courtroom. And interruptions between the justices were very common. I mean, remember, the bench is straight. So, you've got 8 other guys to your right or to your left. And, of course, you can't see when they're, getting ready to speak and whatnot. So, major reforms were needed. So to remedy this problem, Chief Justice Berger requested the construction of an entirely new bench, all right, with angled left and right sides. It is the bench you see to this very day, all right, thereby allowing all the justices to be able to effectively see and hear one another, all right. Additionally, microphones were installed on the bench and the advocate lectern to improve the audio quality of the courtroom. Now, these things might seem like common sense that you would have thought that the court would have had well before that point, but it was not the case. Supreme Court was very outdated as an institution in many ways, many ways, but we're focusing on the things altered by Chief Justice Berger. All right. So after that, the Chief Justice went to work on the hallways and areas near the justices' chambers. All right. The halls in the court at the time were very dark and drably, very grim. Lighting work was ordered and plants were installed to give the area more airy quality, and appearance. All right. Painting and cleaning and polishing of various parts of the court building, especially the giant bronze doors, which, my goodness, having been in the Supreme Court many times, I can tell you those doors are gigantic, all right? Polishing of those doors, it's a lot of work, and that was undertaken, leading to the beautiful appearance that you have today, all right? Another important objective for Chief Justice Berger was for Congress to approve the funding for each justice to hire 3 law clerks. All right. This was readily agreed upon in 1970. Okay. Something Chief Justice Earl Warren had been trying to do for many years before that. Okay. In 1976, the number of clerks was increased to 4. The number it remains to this day. All right. The Chief Justice is entitled to 5, by the way. So Burger also instituted the practice of publishing the syllabus of the court's opinions at the same time the opinion itself came down, rather than after the opinion, as had been the standard at the time. This made it much easier for the press to decipher just what the hell a court opinion was saying. All right? You know, if you've ever read a Supreme Court opinion, sometimes you could be reading it for pages before you finally can get the gist of just what the heck the court is saying. All right? It's not exactly a 2-minute read, if you will. All right? It's easy for us who enjoy reading court opinions, but if you've never read a Supreme Court opinion before, grab a cup of coffee and a Snickers. It's going to be a while. All right? So another area in need of reform was the increasingly burdensome docket of the Supreme Court at the time. So while the justices at that point had almost complete discretion in choosing their docket, wasn't fully there yet, but almost, the amount of appeals arriving to the court was generally beyond that point of respectability. Okay, and reviewing those thousands of appeals was not easy. Reviewing thousands of appeals on a good day, it's not easy, even spread out evenly among 9 folks. So to reduce the amount of in-depth review then endured by the justices, Chief Justice Burger introduced what would be known, as the cert pool in 1972, okay? If you've never heard of the cert pool, it is as follows, all right? The thousands of appeals sent to the court, okay, all requesting cert or certiorari review, essentially, to be given by the court, all right? These appeals are all requesting cert or review, okay? And as the appeals arrived at the court, each one would be assigned to a random clerk at the pool for the justices who wanted to participate in it. For the record, participation in the cert pool is not mandatory, all right? And some justices don't participate in it, okay? So with that, the clerks who are assigned to the pool, all right, each appeal given to the clerk would read the appeal thoroughly, and based on their findings, they would write a recommendation on the appeal explaining why it should be granted or denied certiorari. Okay? You know, and that memo and the appeal would then be circulated among the justices participating in the cert pool. Okay? And then the justices make their own determination on whether or not it should be accepted. For the record, it takes 4 members of the Supreme Court out of 9 to grant cert to an appeal. Okay? You might be surprised at that, but that's how the court's rules work. Although it takes at least 5 justices to get a majority opinion on a case, it only takes 4 of them to grant cert to an appeal. Cert, once again, meaning certiorari, review, to certify areas of law in dispute from the lower court decision with that case. All right? So, that's discussed more in my video on the Supreme Court. I have several videos on the Supreme Court and its jurisdiction in hearing cases. So, check that out on its inner workings of the Supreme Court. All right? So, with that in mind, back to this, the justices would be free to call for a response to a petition from their colleagues based on their findings, as well as the clerks, or both. Once again, participation in the pool was and remains voluntary to this day. The math was pretty simple, okay? Instead of each justice and their clerks having to sort through upwards of 8,000 or more petitions a year, each clerk of a participating justice, on average, would read through about 250. All right. The rest of the petitions being based on recommendations from other justices and clerks. Okay. During the same period, Chief Justice Burger also led the way for the establishment of the Supreme Court Internship Program, the Institute for Judicial Fellows, as well as the Supreme Court Historical Society in 1974. All right. Definitely have been a member of the Supreme Court Historical Society in my lifetime. All right. The Historical Society has the specific intent of promoting the history of the court, its justices, and the effects of its decisions upon American society. All right. Chief Justice Burger's reforms did not end at the Supreme Court, however. Burger was interested in reforming judicial administration in the federal as well as the state courts, as I mentioned above. Okay. By the mid-'80s, the Chief Justice ensured that all federal judges had computers. Remember, this is the '80s, folks, and computers were still pretty rare. All right. Additionally, he led the effort to create the National Center for State Courts in 1971. All right, which through data collection works to improve the administration of justice in various ways at the state level throughout the United States. All right. To improve prison administration, this was really his passion. The National Institute of Corrections was established within the Department of Justice. The Federal Judicial Center was greatly developed. That had been established in 1967. And he instituted the practice of delivering a State of the Judiciary address to outline the state of and needs of the federal courts. Told you Burger was very active as Chief Justice. He behaved at times like this, more like a politician than a Chief Justice, but that's okay. He got things done. His good rapport with the Congress led to the establishment of many more federal judgeships in the 1980s, as well as the creation of the U.S. Court of Appeals for the Federal Circuit in 1982. Okay? So, in conclusion, the tenure of Chief Justice Warren E. Burger, while not remembered particularly for his personal effect on American jurisprudence, he tended to join the great decisions of others more often than author them himself, such as Roe versus Wade and many, many, many more decisions. The Burger era should best be remembered, arguably, aside from advancing women's rights, for its reform of the Supreme Court and the federal judiciary as a whole. All right? With the Supreme Court, he came, he saw, he conquered. He essentially turned the Supreme Court into an episode of This Old House, if you've ever seen that show, all right? Where they take this old near dilapidated property and just bring it back to life, all right? And the Supreme Court in 1969 wasn't far from being this old house, all right? So, it was an institution which was visually and acoustically inept, and he gave it a new lease on life. Okay. Similarly, many internal functions were improved to make the workday much easier for its members, such as the cert pool, as explained above. With respect to the lower federal judiciary and the state courts, many agencies were created, and others greatly improved in their functionality for the proper administration of justice throughout the country. All right. So Chief Justice Burger's legacy lives on in these reforms. All right. And the actual results of his counter-revolution remain with us to this very day. All right. Though his counter-revolution didn't happen with respect to court decisions. All right. It came in the effect of reform to the federal judiciary. And in that way, he is no less a revolutionary than his immediate predecessor, Chief Justice Earl Warren. All right. Some of Burger's other reforms were as follows, and they were very controversial, folks. One reform would have effectively limited court appearances to highly specialized and trained attorneys known as solicitors. This is what they do in England, and Berger thought it might be wise to institute something like this in the U.S., due to the high level of lawyers who, at least he viewed, as very incompetent and unable to try even basic cases in court, let alone high profile and very important litigation at the Supreme Court. So basically, in England, they have barristers and solicitors, all right, highly specialized lawyers who handle courtroom work, all right. They are very trained and, they're anything but incompetent, all right. This is what you study to be, all right. And this is where all your focus goes, all right. The idea didn't really catch on very much. Additionally, he suggested that law school should be shortened from 3 to 2 years, with the last year devoted to a specialty, such as trial practice. All right? That actually doesn't seem like a bad idea, all things considered. You do the first 2 years, your book education, and then your last year is exclusively focused on litigation. Isn't that what you're going to law school for, perhaps? But that really didn't take on very well either. While most law schools today in the U.S. have certainly incorporated hands-on training now as a part of the curriculum, it is a part of the curriculum, and it is not, from what I understand anyway, exclusive in what you do. You still have classroom time, whereas Berger was suggesting that this is what your entire third year be devoted to, learning how to be an actual courtroom lawyer, all right? Learning how to litigate. Like I said, that doesn't sound like a very bad idea to me. I mean, doctors have to go through years of, apprenticeship before they become full-fledged doctors, and, so why would we expect different results from our future attorneys, individuals who we trust in handling sometimes life or death, all right? Doctors handle life and death and have to go through a whole lot more education than lawyers do. Let's just be fair. Lawyers deal with life and death, those who practice in the criminal justice arena, and arguably their education should be no less narrowly tailored on protecting life. All right? So, that is Chief Justice Warren E. Berger and his reforms to the Federal Judiciary, as well as my 2 cents added in there from time to time. Again, this is, from my writing back in 2018 on the subject. I pretty much gave you what I wrote and added things to update the content of the criteria. Once again, if certain things weren't clear, I'm going to read to you once more the cert pool, which is one of the most efficient methodologies ever adopted in the Supreme Court's history with respect to deciding whether or not to accept or deny appeals, okay? So once again, adopted in 1972, the cert pool, all right, is a streamlining process of reviewing appeals. So as the name suggests, the thousands of appeals sent to the court were all requesting cert, or certiorari, all right, to be granted. Certiorari, once again, is review, to be for the court to review the case and certify the areas of law in dispute from the lower court decision in the case, all right? So how it worked was quite simple, all right? Each participating justice would send clerks, to the pool of appeals. As the voluminous appeals arrived at the court, each and every single appeal would be assigned to a random clerk at the pool, okay? The clerk would then read the appeal thoroughly, and based on their findings, they would write a recommendation on the appeal explaining why it should be granted or denied, okay? That memo and appeal would then be circulated among the justices participating, okay? And from there, the justices would make their own determination on whether or not to grant cert, all right? So the justices will be free to call for a response to a petition from their colleagues based on their findings, the clerk's findings, or both, and make their decision whether or not to grant review to the appeal. All right. Then, as now, participation in the cert pool is totally voluntary. All right. Justice does not have to participate in it and can review the appeals individually, one by one, if they so choose. Granted, that is the old-fashioned way of doing it, but certain justices have always preferred the old-fashioned method. All right, there's nothing wrong with that. Retired Justice John Paul Stevens, who retired in 2010 and passed away in 2019, never participated in the cert pool, just for the record. All right, so that's Chief Justice Berger and his modernization of the federal judiciary. Any questions, controversies, leave them down below. I'll be happy to answer them. If you made it this far, thank you so very much for listening. If you learned a thing or two from this video, drop me a like. I'd greatly appreciate that. And if you've not subscribed to my channel, I would truly appreciate it if you did so right now. Just hit that little red subscribe button and that little bell, and we're in business. It's totally free, and you get updates when I post new videos. Again, thank you so much for listening. Take care. Stay safe out there. Be blessed in all you do. And I'll talk to you at the next video. Peace.